Thank you all so much for joining us today. Thank you. Thank you. My name is Tiara Labrada, and I'm the Associate Director of Advocacy and Outreach with the Supportive Housing Network of New York. Thank you all so much for joining us this afternoon for this important webinar on Local Law 15, also known as the Supportive Housing Tenants Bill of Rights. There are a lot of you on the call today, and some of you may be unfamiliar with the network. We are a membership organization representing the nonprofit developers and operators of supportive housing. We engage in lobbying and advocacy efforts on behalf of our members, and we also provide resources, technical assistance, and trainings such as this one. A few housekeeping notes before we get started. This webinar will be recorded and posted on our website under the events section. And then we will open up for Q&A at the end of the presentation, but please be sure to put your questions in the Q&A function down at the bottom of your screen. You'll see a chat. You'll see a raise hand, you'll see a Q&A. Please be sure to put your questions in the Q&A function. That way we can answer them as we go. And then the ones that we need to actually verbally answer, we can do that a lot easier. There are, where there's fear that your questions will get lost in the chat. As you can see, people are actively saying hello and putting things in the chat. So please put your questions in the Q&A function. And we do have a lot to cover, and I know we have a pretty lengthy presentation. So with that, I'm going to go ahead and bring on Jamie Nichols, who's the Acting Assistant Commissioner for the Bureau of Mental Health at the New York City Department of Health and Mental Hygiene, and Gil Walsk, who's a Senior Director at DOHMH. Jamie, Gail? Great. I'm going to stop my screen, and I'm going to pull up your presentation. Thanks everyone for your patience.
Thanks for that introduction, and it's good to be with all of you this afternoon. Jamie Nichols, I have the lucky job of presenting you all a new local law passed by our City Council last fall and going into effect on May 9th. I'm going to use the time today to review the law. We'll talk about provider requirements established by the law. Then I'll talk about requirements of city agencies like DOHMH and HRA that are established by this law. After that, I'll review the template that we've developed for you to comply with the law. The first part of the template will be a part that you should share directly with the exactly as is with tenants, and we'll get through that. The second part is where you will fill in some information based on the particulars of the unit. And then I'll talk about the provider certification piece of the law, which is, we'll get to that. There'll be a lot of questions. We'll leave plenty of time for your questions at the end of the presentation. I think this law grew out of a good place to make tenants of supportive housing aware of their existing rights. It doesn't actually establish any new rights. It just requires supportive housing providers in contract with New York City agencies to give each tenant or prospective tenant a notice of their rights on 4 different occasions. At the time of the interview, at the time of initial occupancy, at the time of lease renewal, and any time upon the tenant's request. We recognize that many of you operate supportive housing programs that are in contract with state agencies, for example, which would not be, expected to adhere to this local law. Nevertheless, these rights are tenants' rights for anybody in New York City, you and me included. And so there is a little bit of potential confusion in that, so the notification is not required for your sort of non-city contracted supportive housing, but the information would in fact be correct because these are existing rights for all New York City tenants. So if you choose to provide it to all of your tenants, I think that's a safe approach as well. Can move on to the next slide, please. And I just want to tell everybody, these are the most boring looking slides in the world. Apologies for that. We wanted to really stick with the letter of the law here. This is new for us. It's new for you. We're going to be learning together how to comply with the sort of the letter and the spirit of the law. But for the sake of adherence to the law, the letter, you borrowed a lot of language directly from that for these slides. So apologies for all the words. I'm going to go through it. And again, please, there'll be lots of time for questions at the end. So the first part, the requirements established for you all, for supportive housing providers in contract with New York City agencies. You must annually certify that you've provided each of your tenants or prospective tenants a notice of their rights. And then there are some minimum expectations about what those rights are. And again, these are rights that already exist in New York City. The unit must be fit for human habitation, free of conditions that are dangerous or hazardous or detrimental to life, health, or safety. Tenant has the right to sue providers. Person has the right to reasonable accommodations and the right to use and occupy housing accommodations without discrimination or harassment. A tenant has the right to learn of available support services and the ability to request changes. Tenant has the right to receipts for rent paid. The tenant has the right to be informed of the impact of adding additional tenants, which may impact on rent payments. And the tenant has the right to form or participate in a tenants association or other groups advocating for the rights and protections of tenants. Moving on to the next slide. Additional requirements for the provider to notify the tenants in this Bill of Rights of all applicable funding streams and government agencies involved in administering the program. This is where it gets a little bit more complicated. We know that it takes a lot to support a permanent supportive housing unit, a lot of different subsidies and relationships with different entities to sort of make it all happen. And so this law, requires some transparency about that and communication to the tenant or prospective tenant. The provider must provide their written policies for handling of any complaints or grievances and eviction processes. The tenant portion of the rent, and identify any other entities and amounts and any subsidies relating to rental payments. The law requires you to tell tenants provide tenants with relevant phone numbers, including but not limited to 311, that the tenant can call for legal advice or representation, including if the provider initiates eviction proceedings in housing court. The law requires supportive housing providers to notify tenants whether the dwelling unit is subject to rent stabilization or Emergency Tenant Protection Act, and whether the dwelling is in a building that gets any tax exemptions or abatements. So that's your part. The law also establishes requirements for city agencies that contract for supportive housing, including that we must provide you with a template of this notice of tenant rights. We must post it on our website and make it customizable for you so that you can complete the rent piece and the subsidy piece and those other elements that are unique to each unit. We have to translate that template We'll make it available in the 10 most frequently used languages in our city. And then we have to receive and investigate and respond to complaints concerning violations of this local law for failure to provide the tenant notice of rights to each tenant and prospective tenant. So there's new work for you and there's new work for us regarding this sort of investigation of the complaints. Any complaints that we get that are substantiated after our investigation, we have to post on our website where we will identify the supportive housing provider about whom we substantiated a complaint regarding this local law, right? Not any complaint, a complaint that the supportive housing provider didn't notify a tenant of their rights. The date the complaint was submitted, the results of the complaint, and the conclusion of our investigation. And then there is a monetary penalty here required by the law. That if the provider is found not to have supplied this notice to each tenant, the provider can be subject to a $250 penalty. We are focused on compliance. We want you to be successful in adhering to this local law. We're going to provide the technical assistance we need to help you cure any violations within 14 days. But first of all, we want to give you the tools, starting with this, to comply with the law. But if we do receive a complaint and we find that in fact you have not provided the notification to a tenant or prospective tenant, we're going to work with you to provide that notification as quickly as possible within 14 days, is what the law establishes, to avoid the penalty. We are again going to focus on compliance. We have not previously been in the position of doing this sort of a penalty approach. We will have to comply with the law and figure that out. But I think this is a reasonable process, and I'm confident you all will be able to adhere to the law. We will share this the template that we're required to develop with you as soon as possible. I would have loved to have had it with me today, ready to share. Just making sure we get all of the right approvals has been a little bit slower, and so we expect to get it out to you by the end of this week. There will be translations into the languages, 10 most common languages. Those are forthcoming. I don't know exactly when those will be done once we finalize the template and then get it translated. So as quickly as possible, we'll get those to you. And the template and the translations will both be provided, available on DOHMH's website. We'll make sure to get you those links as soon as they are live. We'll also send it out via email through our normal sort of channels of communication. The law requires that you read the notice to tenants who have difficulty reading, or assist tenants with translation services if the notice is not translated into the tenant's preferred language, right? If it's not one of those 10 listed previously. We strongly recommend you use the template that we provide to you. We have taken great care to make sure that it complies exactly with the law. It'd be great if you just took it and built it into your workflows. That seems like the safest approach possible for all of us. Move on to the next slide. So there's two parts of this template, as I mentioned. There's going to be the part that sort of lists all of these rights, and then there's going to be the part that sort of provides information, like details specific to the unit. So this slide and the next few slides is the part that lists the rights that a tenant has in New York City. This is the part that we, really strongly encourage you to just verbatim directly, provide to clients in your form and verbally if you need to read it. Going to read it here again just to make sure we're all hearing this for the first time. Apologies for the excessive text and boring nature of this. But this is important. As a supportive housing tenant, you have the right to live free of dangerous or hazardous conditions such as pests, leaks, mold, broken fixtures. You have the right to utilities like heat, hot water, electricity, and gas. To make a maintenance request, call your building's maintenance team or your supportive housing provider using the contact information under building information below. That's the part at the end that you all will fill in. Call 311 to report any ongoing issues that have not been repaired and to request an HPD inspection of your home. The property owner or housing provider must provide you with a copy of their grievance procedures upon enrollment, lease renewal, when updates are made so that you know how to respond to any problems with your unit. Supportive housing tenants have the right to file a court case against their property owner, property manager, or supportive housing provider to correct violations of the city's maintenance code, including harassment. Call 311 and ask for the tenant helpline or visit your borough's housing court for more information. If your property owner has locked you out or is trying to make you leave your housing, call 911 right away to report an illegal lockout, then call 311 and ask for the tenant helpline. And it gets a bit into the court proceedings before you can be evicted. Again, this is all stuff that exists currently, but is not compiled into one place and provided to tenants until now. You can receive free eviction defense legal services, regardless of your zip code or immigration status, under New York City's right to counsel. To be connected to a free attorney, we provide phone numbers for that. Nobody can evict you without a judge's order. You must also receive a notice from the city marshal or the office of the sheriff before you can be legally evicted. And the person or entity that's trying to evict you must file a petition through housing court, and provides some phone numbers about that as well. Lastly, a tenant has the right to receive rent receipts and request a current ledger of rent payments and rental arrears, as well as copies of annual income recertifications, leases, and occupancy agreements. And a person, can contact their provider with the details that you all will fill in for your particular organizations, programs, and units. So moving on, the additional rights that each tenant of New York City has are the right to request reasonable changes to their housing services or both, to accommodate physical, mental health, or behavioral disabilities, and to be protected from discrimination in housing. To request an accommodation for a disability, contact your supportive housing provider using the information that you all will fill in for your unique situations. There's a phone number to contact if a person believes their rights have been violated with the New York City Commission on Human Rights. Notify your social service provider if you wish to add others to your household, such as a minor or adult child or a spouse or domestic partner. Your provider will discuss the implications of adding others to the household, including determining if the housing is appropriate or legally permissible for additional occupants. Any income eligibility limitations your housing may have, such as those imposed by tax credits, and discuss how the rent calculation in the lease or sublease may change. This, I know, is a complicated issue. We've attempted to, adhere to some language that New York State Office of Mental Health uses to be as consistent as possible across your supportive housing portfolios on this topic. And lastly, I think this is the last one, tenants have the right to join or form a group, such as a tenants association, to advocate for the rights and protections of tenants without harassment, retaliation, or punishment. They can hold these meetings in common areas and buildings in your building without having to pay a fee to use the space. However, advance notice should be given to the supportive housing provider, right? Just so you can arrange use of common areas. So that we just finished up the part that, each item, I think you can just copy and paste or, from the template, put on your letterhead if you want, to provide to your tenants or prospective tenants. Then this piece is where you fill in information for your particular organization, your particular program, particular unit, and the person you're interviewing, right? I'm not going to go through each box here. You'll get this template. This will be in a fillable form that will be on our website. It gives you an opportunity to sort of add multiple points of contact. You don't have to fill in every box, just the ones that apply or to the unit and the person that you're interviewing. Can move on to the next slide, please. You'll see more boxes for you all to fill in. With addresses, more contact information, the calculations of the rent, the tenant portion, information about subsidies and tax abatements, etc. Can move on to the next slide, please. At the end of the template that we will provide with to you, there's a place where the prospective tenant or the permanent tenant, right? Because you're going to give this to people that you interview as well as people that move in. They're going to acknowledge receiving a copy of the notice of their rights. And then you must give a copy to everybody, all your prospective tenants and permanent tenants, and also put a signed copy into the person's file for your records. I saw a question somewhere about how long you have to maintain that. I don't know the answer to that. That's one we'll have to follow up on. Moving on to the next slide. Each provider in contract with a New York City agency for supportive housing must provide an annual certification to their funder, right, to DOHMH, confirming that you adhered, or certifying rather, I should use that word, certifying that you adhered to the local law. You will provide that to us annually at the end of the first year of implementation. So this law begins May 9th, 2022 is when it goes into effect. So by May 8th, I guess, oh geez, sorry, a year from that date, by then, no later than a year from that date, you should submit this annual certification to DOHMH. We will provide a dedicated mailbox for this certification to go to. That'll be when we send out the template, we'll include that information there. So you'll certify that you adhere to this for all the people that you interviewed, right, at these 4 points in time that you interviewed for units, at the time of initial occupancy, at the time of lease renewal, or upon request. You send that to us. We keep it on file as part of our agency responsibility.